2013 Travis Oak Creek LP versus Shakira Law. This case was filed on the 10th of December of 2024, and there's an amended petition that has also been filed on the 6th of January. I spoke with the attorneys and they're ready to proceed. And so we are going forward today on the hearing on a trial before the court. Today, the court will make a decision based on the evidence presented. The burden of proof is on the plaintiff to show me by a preponderance of the evidence that they're entitled to the great right of possession, that there's some violation of the lease, some sort of violation of the landlord-tenant relationship, and that they've given the proper notices. And so they have that burden of proof to show me that that's what they've done. Ms. Law and her attorneys have the opportunity to ask questions of the witnesses that Mr. Lung is going to present on behalf of his client, and then present their case in response to the eviction. So the judgment from the court today is not a final judgment, but is appealable, and each side will have at least 5 days to appeal the judgment and posting the proper bond as required by law. So I'm going to go ahead and proceed then. Mr. Lung, I'm going to have you give me an opening statement on this case, and then if you want to give me an opening statement on behalf of the defendant, Ms. Goldstein or Ms. Dunlap, please do so. And so I'm going to swear in the witnesses. Mr. Lung, you said your witnesses are Ms. Law, Mr. Ramirez, Mr. Martinez, Christy Neil, and Emily Davis, right? Ebony Davis. And so is Fanny Harrell, who is she a witness for?
She's our witness, Your Honor.
Okay. I'm going to swear all the witnesses in to start off with. So if all the witnesses will raise right hand to be sworn in, please. Do each of you solemnly swear or affirm that the testimony you're going to provide this court will be the truth, the whole truth, and nothing but the truth to help you God? I see people head nodding and some, I don't see anybody saying no. So
yes,
it's under oath. All right, so thank you. So Mr. Long, you want to give me an opening statement? Why are we here today on this case involving Travis Oak Creek and Shakira Law? Oh, you're on mute right now, Mr. Long.
Yes, Your Honor. May I please the court? So this is a forcible detainer action filed by the plaintiff. In our testimony, you're going to hear testimony that Ms. Law has been residing in the premises for quite some time. And then you will hear testimony that she has threatened to kill another individual. And not on one occasion, but on multiple occasions. Based on her conduct, a police was called, and based on the criminal activities, as the lease provided, that because of criminal activity, there's a default under the lease. Secondly, the lease, the expiration date of the lease has passed last year. And then when the lease has passed, either part under the subsidies housing, a tenant can terminate the lease by providing a 30-day notice of termination. You will see by plaintiff's evidence that Ms. Law has provided a 30-day notice of termination, terminating the lease, but since then, 30 days has passed, and then she has refused to pay, to vacate. And lastly, she has not offered to pay rent starting the month of August of 2024 up to today. So we're filing for 3 different grounds. There were criminal conduct, a holdover, and for non-payment of rent issue. And at the conclusion of the hearing, we respectfully ask this honorable court to grant us a possession of the premises and court costs and back rents.
All right. In response, do you have to do an opening statement, Ms. Goldstein, or do you want to hold off on doing that at this time?
I'm sorry, Your Honor. I have an opening statement. If my microphone cuts out again, please let me know. I can always switch to my co-counsel's computer.
All right.
Plaintiff, who does business as Lucero Apartments, is a federally subsidized housing provider that participates in the low-income housing tax credit program and the Section 8 project-based rental assistance programs, which allows evictions only for material breaches of the lease. It also means that residents who live at Lucero Apartments are entitled to special protections under the Violence Against Women Act. Under VAWA, or the Violence Against Women Act, a tenant who experienced sexual assault has the right to request an emergency transfer to another unit at the property and to be given certain priority on a wait list if a unit isn't available at that time. The reason this is relevant is because on April 27th, 2020, I had to connect to our Ethernet because of issues with our Wi-Fi, and I'm very sorry about that.
That happens.
Okay. I'm just gonna continue where I left off, if that's all right.
Okay, you were talking in April, something happened. Is where
Yes.
where I left off.
So the reason VAWA is relevant is because in April 27, 2024, Shakira Law was raped in her apartment at Lucero. She called the police that day, her rapist was arrested, and immediately afterwards, she began receiving harassment from friends and family of her rapist who lived at Lucero Apartments. 2 days later, Ms. Law reported her rape to the leasing office to a property manager named Renee Cole. Renee Cole completed an incident report documenting the assault. Ms. Law completed paperwork with her that she was told was for VAWA, the Violence Against Women Act. And Ms. Law filled out that paperwork, turned it in, and requested an internal emergency transfer to avoid further harassment from people associated with her rapist. This court will hear evidence that Shakira Law spoke to Christy Neil, regional manager for Lucero Apartments, shortly after turning in this VAWA paperwork. She asked for an emergency internal transfer. Christy Neil simply told her that Lucero and its sister property were 100% occupied, no transfer would happen. She didn't put Ms. Law on a waiting list. She didn't offer her resources. In July, after months of harassment from her rapist friends and family, Ms. Law got into a verbal altercation with another tenant, Stephen Martinez, a man associated with her rapist. Ms. Law will testify that Stephen Martinez taunted her, cursed at her, and then picked up his phone and recorded her response. Plaintiff is going to make completely unfounded accusations of criminal activity, but there's no credible evidence of criminal activity. There's no police report, there's no lease violation. This was not a material breach of Ms. Law's lease. Around the same time, Lucero began refusing to accept Ms. Law's rent. She offered rent in July, and a property manager named Ty said she would not accept it because Ms. Law was going to be evicted. Now, Lucero wants to evict Ms. Law for non-payment of rent when her failure to pay was solely because Lucero refused to accept the rent. This is not a material breach of her lease, and she'll testify that she can pay her entire rent balance today. Finally, Lucero alleges that Ms. Law terminated her lease on her own accord and then failed to move out. That's simply a misrepresentation of what actually happened. Earlier, I talked about VAWA paperwork that Ms. Law handed in and filled out in the office in April 2024, shortly after her rape. One piece of paper that Ms. Law turned in with her VAWA certification was a blank but signed notice of lease termination under the Texas Property Code. Ms. Law didn't intend to terminate her lease. She wanted an internal transfer, and that's why she didn't put a date on the lease termination when she turned in the packet in April. In July, Ms. Law finally complained to Southwest Housing Compliance Corporation about Lucero's failure to respond to her request for an emergency transfer. Christy Neil finds out about the complaint and calls Ms. Law into her office, where Ms. Neil tells Ms. Law that she can, quote unquote, take the VAWA or get a 3-day notice to vacate for her argument with the neighbor. Ms. Neil repeatedly bullied, pressured, and misrepresented the protections under VAWA until Ms. Law, feeling like she had no other choice, said that she would, quote, take the VAWA and move out on her own to avoid eviction. Ms. Law recorded much of this meeting, and the court will hear those recordings today, but I want to share a few impactful quotes from Christy Neil before I wrap up. Quote, let me explain to you how VAWA works, okay? And I'm recording this. We have it on recording. It's a VAWA. Once you file it, That means you are saying you are in immediate danger, that you have to move out of your unit, end quote. This is simply false and a misrepresentation of VAWA. Christy Neil also threatened to evict Miss Law's mother, who's here today, if Miss Law didn't agree to leave on her own. She said, quote, and then guess what I gotta do? Because if I evict you, guess what you're gonna do? Move right in with her being your mother. And so guess what? She's about to get her 3 days, end quote. When Miss Law asks for protection against her abuser, Miss Neil says, quote, security is not here for the safety of the residents. The security is here to protect the asset of the owners as well as the gates. We can't promise you protection because we have security. And when asked if plaintiff would ban Miss Law's rapist from coming on the property, Miss Neil laughs at her and says, quote, I can't sit here and babysit the property. At the end of the meeting, Christy Neil wrote a date into the lease termination notice that Miss Law previously signed. Miss Law will testify today that she was not present when Christy Neil wrote in that date. Miss Law did not want to move. She never wanted to move. She simply wanted Lucero Apartments and Christy Neil specifically to follow the law and afford her protections under VAWA, which it did not do. And so for these reasons, we're asking the court to grant a take-nothing judgment in Miss Law's favor.
All right. Thank you, Ms. Goldstein. I have some questions, but I'm gonna let the evidence play out and see if my questions get answered by the testimony. So, Mr. Lung, who's your
Judge.
first witness?
Mr. Martinez.
Okay, Stephen Martinez.
Yes, sir. Can you hear me,
I can
Judge?
hear you. Yes. Do you have a camera?
Yes, sir, I
Your
do.
computer? Could you turn on your computer camera, please?
Yes, sir.
All
Good
right, thank you.
afternoon. How you doing, sir?
Yes, you were sworn in, Mr. Martinez. Is that right? You raised your right hand when I swore everybody in.
Correct.
Okay, Mr. Lung's going to have some questions for you, and then one of the attorneys for the defendant will also have a chance to ask you questions. If you don't
Okay.
understand the question, ask him to repeat it.
Yes, sir. Understood.
All right, Mr. Lung, please proceed.
Of course. Mr. Martinez, can you hear me okay?
Yes, sir. I can hear you just fine.
All right, can I call you Stephen?
Whatever works for you, sir.
All right. Hey, Stephen, thank you for coming today. So,
Yes, sir.
Stephen, yes. So how long have you been living in the Lucero apartment?
For more than 4 years already.
More than 4 years. So for more than 4 years, I assume you will be familiar with the neighborhood or who is there, who is not there, right?
So to sum that up, I've been living here on my own with a unit under my name for 4 years, but I've been in these apartments since Lucero was all Oak Creek once. And that was since I was 11 years old. Up until now, I'm 30 now. And since then, it's the same faces. Everybody's still here, same people, really. So it's like a second family, you could almost say. Everybody knows everybody.
Okay. So, Mr. Martinez, tell me, you live in Unit 15, correct?
No.
And are you really close to Miss Law apartment?
So she's on the 3rd level, and I'm on the 5th level. And they count the 2 parking garages underneath Miss Law as the first 2 floors. And then, but I think her floor is actually the first one. And then, so you could say I live on, they label it as the 5th floor, and she's on the 3rd floor.
Okay. Would you say you have a good relationship with the defendant, Miss Law?
No.
Okay. So why is that? So when did you get to know Miss Law originally?
So I've known her mother since, like I said, we all been here a long time. So I've known her mother since I was a kid.
Okay. So pretty much says that you knew Miss Law for a while as well then, right?
Correct.
Would you say you're close to her?
No.
But you would say hello or?
Yes, say hello here and there sometimes, yes, but prior to the incidents occurring.
Okay. So you have called the police on Miss Law before, right?
Objection leading.
Okay, I'm going to sustain the objection. So, re-ask your question, Mr. Lung.
Okay, so Your Honor, we are enforcing the rule of evidence today.
We are he's saying you're leading the witness. Go ahead and ask questions that he can answer open-ended.
Okay, all right. Mr. Martinez, have you ever called the police on Miss Law?
Yes.
And when was that, the first time?
The very first time was when it was a couple months back. I was taking out my dog, and she was with a group of people, and I walked by her and those group of people with my dog, and one of the people in her group was like, "That's a beautiful dog," and I said thank you to that person that was in her group, and then she said, "Yeah, that is a pretty dog, but his owner's a big ass." Her words, word for word.
Okay. But then why did you call the police at that time?
Because I wanted that wasn't the first time she had been verbally assaulting me. So I was like, you know what? I'm tired of this. You know, before this, she just verbally been saying stuff, nothing physical, just verbally. And
Your
so,
Honor,
so
we
I
would have, I'm sorry, Your Honor, we would object to this line of questioning. There's no evidence that this is one in the petition, two in any termination notices. I believe there's one incident listed in the petition, and we would ask that, and one incident listed in the termination notice. The HUD handbook that governs this property prevents them from bringing up evidence that's not in the termination notices in an eviction, and we would ask them to keep it to what's in the petition.
I think it still should be noted though, because it led up to that.
So there's a little bit of back. I'm going to allow a little bit of background, but let's focus, Mr. Long, on what you have in the petition. So let's get to that instead of all the superfluous stuff.
Sure. Mr. Martinez, there was an incident happened between you and Miss Law on July the 10th of 2025, correct?
Correct.
And you have recorded the incident, correct?
Correct.
You claiming the incident that Miss Law threatened to kill you.
Yes. So what had happened that night specifically, once again, I was coming out the elevator, going to take out the trash. I had my hands full. I had 2 trash bags. I was doing the seasonal cleaning. I had 2 trash bags. I'm getting out the elevator, and Miss Law, her father, and another young lady in a unit above her were talking right in front of the elevator, to the point where when the elevator door opens, if they don't get out the way, I can't get out. So I was like, "Excuse me." And I walked by, and as I'm walking by, she was already having a discussion with her father and the young lady there. And when I walked by after I said, "Excuse me," she was like, "Yeah, I know what you're saying." And once again, she referred to me as a bitch ass and was like, "Yeah, these ass walk around here tough, but this and that, but won't fight." And then at that point, like I said, prior to this, there's been many incidents to where, like, I passed her unit. I passed her unit to get to the elevator.
Yes. Oh, Mr. Martinez, let's go ahead and wait. There's not a question on the floor right now. Let's go ahead and hold off. You answered the question as far as this recorded. Let's talk about this July 2024 incident. Okay.
Okay. Yes, sir.
I think you was describing what happened. Yeah.
Yeah, I was describing what happened. So once again, I'm coming out the elevator, and then she calls me a bitch ass nigga, and I bite the bullet and I keep going because it's this verbal assault. So I keep going, and then she's like, "Yeah, but you won't fight nobody," and calls me a pussy. And then that's when I had enough, and I turned around and I said, "You know what? Fuck you, bitch. I don't say nothing to you, and you just keep talking shit to me. That's why you keep talking shit to me, because I don't say nothing to you." I told her, "Today's the day. I'm recording your ass." And I recorded. That's when I pulled out my phone and started recording her. And then she was like, "I don't give a fuck about you recording. I don't give a fuck you, Steven," and this and that. And then she was like, "I will get somebody over here to whoop you. I will get somebody over here to whoop your ass." And then I was like, and these are her words. And so I'm like, "Oh, do what you got to do. It's all being recorded." And I'm recording her, holding my phone up in her face, telling her, "Do what you got to do. I'm recording." And that's when she repeats herself, "I don't care if you're recording again." And then at this time, I throw the trash out. And so then and I come back upstairs, and then because my adrenaline is rushing at that point. And even her father, that day, her father that was outside with her had told her, "Why are you talking mess to him? He didn't tell you nothing. Why are you saying things to him?" And then she was like, "I'm tired because all of these are talking about me." I'm like, "I don't even talk about you. Like, I got my own life, my own children to worry about. I'm not worried about you. You got all this stuff going on. All in the apartments has nothing to do with me." So after that incident happened, I threw the trash, and like I said, I came upstairs, and she stayed out in the courtyard where I could see her from. I came to my patio so I can continue listening to her what she was saying, and I continue recording her, and so I could have proof, and I did, and then she was threatening to get somebody, and then I seen a car arrive here, and then that's when, and keep that time, my family was on a walk. So all this is going on while my family's on a walk. I don't want nobody to get here with the gun and saying, and my family is approaching and my family in danger now in the line of fire. So I go back downstairs after I came to my unit for that reason. And I had a couple friends that were at the entrance of the apartments, and they were like, "Nah, Steve."
Hearsay.
He was like,
Okay, whatever your friend said, I mean, let's talk about what was said to you and what you said, okay?
"No, yeah, that's what I'm saying." After that was said, I went downstairs, and my friend seen me, and he said, "Just go inside. I don't want you to get in trouble, bro. Go inside. When I see your family approach on Wilson Street, I'll walk them to your apartment." So that's what happened. But as I was down there, before my friend told me that, I seen a car arrive, and two black males got out, and one got out the driver's seat and had a gun in his waistline, and he was pulling it out as he went around the car and gave it to the other black male that was in the driver's seat. And the black male grabbed the gun, put it in his waistline, and then the other one that got out the passenger seat got in the car and took off. And then the guy that grabbed the gun from the passenger walked towards Shakira's apartment, Miss Law's apartment. And that's when I guess he was trying to find out
Objection.
who he needed to shoot.
Objection. Mr. Martinez, when I say objection, please stop talking.
So is it your objection to speculation, or what is your objection?
Yes, speculation.
All right.
Yeah, Mr. Martinez, you saw those black gentlemen, they walked to Miss Law's apartment, correct?
Correct.
Objection. He said he saw them walking in the direction of her apartment.
Well, I have video proof. It's in the videos.
Objection. We were not provided any videos
Well,
from plaintiff.
Ms. Goldstein, I was asking if he had seen it. That's a different question. I'm just bringing more testimony.
But
Oops.
yes, to answer your question, sir, I did see him go to her unit, but she didn't come out the unit to talk to him. The father of Miss Law came out the unit to talk to him.
Okay, and you saw these with your eyes, correct?
Correct.
Okay. In your mind, was that an empty threat when she threatened to kill you?
Yeah, heck yeah, because where I grew up, and I grew up faster than what I was supposed to, and and I've seen things I ain't supposed to at a young age, and I've lost family members to gun violence, and I take that serious. I like I said, my family was probably 5 minutes from arriving back from their walk.
Okay.
I'm not gonna risk none of that. So
Okay.
so once I seen the gun in him, and I took my friend's advice. He told me, go upstairs. I'll walk your family through the other side of the property and make sure they get home safe. I said, okay, thank you. And that's at the same time as I'm watching this individual just made a hand-to-hand change, grabbing a gun from somebody else and walked to Mrs. Law's apartment. And then that's when her dad greeted him and told him, you can't be here. It's your fault she's acting like this. And that's all in the video proof. It's all verbally. You can hear it clearly in the videos.
And you recognize the relationship between the gentleman and Miss Law?
Well, I've never seen him before, but obviously he was there for her because he went straight to her unit. But Miss Law's father didn't allow him in. And then Miss Law started cussing out her father and telling him to leave. And he's a piece of shit and things like that nature. And that he's not her real dad. And
Objection. I don't understand how this is relevant to anything.
Okay. Well, we're kind of going a little bit further afield. So let's stick to what you're trying to get to, Mr. Ling, please.
Yes, Your Honor. If I may have permission to share my screen. Mr. Martinez, you see on my screen, there is like a film pull up. You see that?
Yes, correct.
You recognize this as the video that you filmed?
That's exactly the video I recorded. And from where they're standing and where I'm standing, when I got to that corner where I'm standing, she was still verbally assaulting me and calling me every name in the book. And then that's when, I had enough.
Okay. Your Honor, if I may have my permission to play the video.
Any objection, Ms. Goldstein?
No.
All right, proceed then.
Go ahead. Keep going. All right. I don't touch you. I don't touch you.
You want the motherfucking outside to me, man?
I don't touch you.
Mr. Martinez, in the video, she threatened to get someone to
Objection, leading.
What, I didn't hear any audio on that.
Oh, Your Honor, you didn't hear any audio?
No.
Let's see if I can get that to you. Your Honor, I do have a Google link that I can send to you if you can want to play it. Can you see it?
Yes, I can see it.
Okay, go ahead.
Can you hear it?
Not right now. It's paused.
Go ahead. Keep going. All right. I don't touch you. I don't touch you.
Can you guys hear the sound?
Yes, we can hear the
Perfect.
sound. Now I don't hear anything.
Oh, now you don't hear?
No, it cut off.
I don't touch you.
Did you hear that, Your Honor?
No, I did not hear that.
Okay. Your Honor, if I could, I can send you a Google link, then maybe you can play it on your computer. Would that work?
Can you send it to the clerk, please?
Yes, Your Honor, I will put it on the chat box right now. I apologize for. Your Honor, I put the link on the chat box. Your Honor, it is the video ends with 8249.
Mr. Long, I think the video you sent is not the correct one.
It's 8249, Your Honor. There's three.
What you put in the chat is not that.
There's 3 videos in there.
Okay. Can you see 3 videos? I saw one. I didn't see.
Oh, it's 82. Huh, that is really weird. Let me send you another one.
It's not showing up. Okay, then share. All right.
So,
Ms.
Mr. Mart-
were y'all able to hear?
No, Your Honor.
Oh, you weren't able to hear it?
Yeah, but Your Honor, the video was previously provided to Ms. Goldstein.
Yes, Your Honor, we've watched the video.
Okay, no, I've heard it. I did not hear. I didn't hear anything about a gun. It's just someone come get you, but I didn't hear a gun threat. So
Right. So, Mr. Martinez, but after that, she stated there was-
Objection, leading.
Your Honor, it's not leading. I'm just simply establishing a timeline.
okay. So what happened? What happened after then?
So, yeah, wait, Mr. Martinez, what happened after the video?
So after the video, like I said, I continued to go throw the trash what I was doing originally. And then that's when I sat outside for a little bit to see if my family would come back, because I was just worried about somebody coming and my family being in danger. And so, but that's when, like I said, I seen my friend and he told me go inside, don't get in trouble. You already recorded, you did what you have to do. When I see your family, I'll take them to your unit from the other side of the complex where they won't be in any danger.
You stated that already, so what happened after that?
So then after that is when I was just antsy and I couldn't really, they didn't work. My family wasn't coming back quick enough. So I went back outside. And when I went back outside, that's when I seen the car arrive with the two individuals that I said had the gun. And then I seen them switch off. The passenger got out, walked to the driver's side. The driver got out, grabbed the gun from the passenger, and then they switched seats basically. And the passenger gave the driver the gun. And then the car drove off, and then the guy with the gun continued to walk to Ms. Law's apartment. When he got there and knocked, he was greeted by her dad. And then that's when I went upstairs because I didn't want to get shot. So I came upstairs, and then I started recording from the floor above her to hear the whole transaction, which is one of the videos of the three that.
Mr. Martinez, did you believe that when she threatened you, the threat was real?
Yes.
Okay. Your Honor, I pass my witness.
Ms. Goldstein, are you going to ask questions, or is Ms. Dunlap?
I am, Your Honor. Mr. Martinez, can you tell us your full legal name?
Stephen Nassif Martinez.
Mr. Martinez, would you consider yourself an aggressive person?
No, sir. No, ma'am. Correction. Sorry.
But Mr. Martinez, you were convicted of assaulting your ex-girlfriend at Lucero Apartments
Your
in
Honor, objection.
23, correct?
Relevant.
Your Honor, I believe this is relevant for impeachment. He just said he doesn't consider himself an aggressive person, yet he was convicted of assault on the property.
Your Honor,
You can answer the question. I mean, there's always circumstances, but is it true or is it not true that you were convicted of an assault?
What was that, sir?
Is it true or not that you were convicted of an assault on an assault case?
I got it. Yes, sir.
No further questions. Your Honor.
redirect, Your Honor.
Anything else?
Mr. Martinez, were you ever aggressive to Ms. Law?
No, sir.
Oh my God, stop fucking lying.
No further questions, Your Honor.
May I have a chance to say something?
Objection. There's no question asked.
Mr. Martinez, I know you want to say something, but there's no question that let's go ahead and hold off on giving an explanation as to what you feel is relevant. Anything else, Mr. Lung?
Mr. Martinez, how long was the assault when you were convicted?
What was that, sir?
Were you convicted with an assault, or were you just charged with the assault to your girlfriend?
I wasn't convicted. I was charged.
And was it dropped later?
Yes, correct.
Okay. Your Honor, no further questions.
Your Honor, may I share my screen?
Yes, you may.
Can you all see my screen okay?
Yes.
Yes.
Mr. Martinez, is this, I'm first going to go to this register of actions for Travis County. The Stephen Nassif Martinez, assault causes bodily injury, family violence. Is that you here?
I can't see. Everything's too small on there. Everything's super small.
I've made it larger. This is your name, correct?
Correct.
And it says below here, final disposition and jail sentence satisfied. Is that correct?
Correct.
So you served jail time for this conviction, correct?
Correct.
Okay, no further questions.
When was the incident date?
2019, Your Honor.
The conviction was from 2023, Your Honor. The offense date was 2019.
Okay.
Your Honor, I want to call Ms. Law, Ms. Shakira Law, to be my witness.
All right. Can Mr. Martinez be excused? Okay.
Yes, Your
So-
Honor.
Mr. Lung, any reason to, are you going to go recall Mr. Martinez for any reason?
No, Your Honor.
Okay. Mr. Martinez, you're free to stay if you want to watch, or you're also free to be excused. Okay.
Okay. Yes, sir. I appreciate it, sir.
Thank you.
Right.
Mr. Lung, who's your next witness?
Ms. Law?
All right, Miss Shakira Law,
Yes, sir.
is your microphone on? Will you say something so I can hear you?
Can you hear me?
Yes, I can.
Okay.
All right. Mr. Lung's gonna ask you some questions, and afterward, Ms. Goldstein may ask you some questions, or Ms. Dunlap. But if they object, please hold off on answering the question that they ask until we rule on the objection, okay?
It's your honor.
All right. Mr. Lung, please proceed.
All right, Miss Law, can you hear me okay?
Yeah.
So, Miss Law, you're the defendant in this case, correct?
Mm-hmm.
Miss Law, isn't it true that on April of 27 of 2024, you obtained a document from the definition, the sexual assault victim advocacy program?
Yes, I had got a packet from there after my kit.
Can you repeat your answer?
I said yes, I had got a packet from there after my kit after being on the weekend.
So you got a packet from them.
Mm-hmm. But it
And
was
then-
not fully signed.
Okay. Now, Miss, Your Honor, can I share my screen?
Yes.
Okay. And Miss Law, this is the document that you obtained, correct?
Yes, sir.
Dated April 22nd, signed by a SAFE Sexual Assault Victim Advocacy Program?
Mm-hmm.
Okay. So, Ms. Law, you're providing this document under Texas Property Code 920161C3, which is you can terminate your lease under victim of sexual assault, penalty free, correct?
Yes, sir.
And then, Ms. Law, you signed this document under here, Ms. Shakira Law, correct?
Yes, sir.
And you signed this document on April 29th, 2024, correct?
The day after I got it, well, 2 days after I got it.
Okay. And then this letter, you understand this letter, right?
I got an impression of something else when it came to Valor.
Objection, Your Honor. Non-responsive. I asked yes or no question.
Would you make it a little bit bigger, Mr. Lung?
Oh, sure.
I can see your whole other stuff on your screen. Yeah.
Oh, okay. Ms. Law, you have read through this document, correct?
The property manager at the time read it for me.
Ms. Law, this document titled 30-day notice to vacate, correct?
Yeah, but they also told me that I could move units within this
Objection, Your
vacate.
Honor. Non-responsive.
Sustained. Continue, please.
Okay. And Ms. Law, you signed these documents, right? Is this your signature? Ms. Law?
I say yes, sir. Can you hear me?
Yes, now I can hear you.
Thank
So you turned in this 30-day notice to vacate, to terminate the lease to the property manager at that time, Ms. Cole, correct?
Yes.
Okay. You
I
turned-
don't understand that question really.
So you turned the documents to Ms. Cole, the property manager, on April 29th, 2024.
Yes, but it was never acknowledged within those months.
Objection, Your Honor, non-responsive.
Sustained.
And Ms. Law, that's a 30-day notice to vacate, correct?
Yeah, now that I see now.
Yeah. And then, Ms. Law, under your lease, that for you to terminate the lease, you understand you have to give a 30-day notice, correct?
Yeah.
So you turning that notice on April 29th, 30 days, can I say your lease was terminated on May the 29th?
I'm not sure.
Your Honor, she's asking for her attorney.
She says she's not sure.
Oh, okay, she's not sure. Okay. Your Honor, then if I may share my screen for the lease agreement. So, Ms. Law, this is your lease agreement. You signed this on May of 2022, correct?
You said it was signed May 2022?
Right. It's on here. This is your signature, and that was signed by you in 2022 in May.
No. Is that the termination? No.
This is the lease.
Yeah, that's my lease.
Okay. So, Ms. Law, under paragraph 23 of the lease, here, it states to terminate the lease, the tenant must give the landlord 30 days written notice before moving from the units, correct?
Yeah.
Now, Ms. Law, so as answered earlier, you have given a 30 days notice of termination, correct?
Yes, but the aspect of how I got it was viewed all different. I didn't think
Your
I was
Honor,
something.
objection non-responsive.
Saying,
Now, Ms. Law, this is the statement that you submitted through your attorney to me last week. That you type it up all nice. This is your documents, correct? It states here, you did not move out because you have nowhere to go with your children, correct?
Yes.
Okay. Now, Ms. Law, between your submitted the 30-day notice of termination through today, how many housing applications have you submitted to other housing?
Objection relevance, Your Honor. There's no relevance to whether or not she submitted applications to other apartment complexes.
Your Honor, it is relevant because this turned into like she has failed to mitigate her what she's seeking, which is stay in possession, but she could have, if she has submitted other application, that she should have been gone. But we're trying to establish that it is maybe either in bad faith or that she hasn't even performed any due diligence to try to relocate.
Again, Your Honor, there's no relevance to whether or not she submitted applications to other apartment complexes. She doesn't have a duty to mitigate that. If she chooses to stay in possession because she thinks that the termination notice was signed invalidly, then she's allowed to do that. She's allowed to have her hearing in court.
okay. I'm going to sustain the objection, Mr. Long. Move on, please.
Okay.
Don't worry about the objections.
So, Ms. Law, when you turn in the 30-day notice of termination, did anyone force you to turn them in?
Yes.
Who did?
Christy Neil.
Now, Ms. Law, you stated that you turned in that note in April,
Yes.
but you did not meet with Ms. Neil until July.
No, I met with her a couple of times before that meeting. I just recorded it. I met with her the same week I had signed those documents, and it did not get acknowledged because she told me out her own mouth that there was no units, nor in the sister neighborhoods there wasn't units, there's no waiting list, and that I was going to
Objection,
have
Your
to
Honor,
find.
relevant.
Hold off on answering any questions until you ask you, okay, Ms. Long?
Yes, Your Honor, I'm sorry.
Just one question at a time.
Ms. Law, that 30-day notice of termination was submitted in April
Was it? No.
to Ms. Cole.
Yeah, Miss Renee got it started, but nobody finished it until she was trying to evict me.
Ms. Law, isn't it true that you turned it in April, on April 29?
Yes.
Okay. Your Honor, no further questions. Pass my witness.
All right.
Right. Okay, Mrs. Law, I have a couple of questions for you. So I'm going to go ahead and share my screen. Yeah, that'd be good. Thank you. Mrs. Law, I'm going to start with the 30-day notice that Mr. Long was referencing. So, Mrs. Law, this document, when you turned it in to the property on April 29th, what was your understanding of what this document did?
Well, Miss Renee had told me in Safeline
No, no
that
objection.
What's your objection, Mr. Long?
Intent of a document is not relevant because under the Four Corners rules that you cannot use extrinsic evidence to interpret the document that was turned in has to be just within the document. And the intent is not really relevant.
Okay,
I
I'm
think
going to overrule the objection. I'm going to have Ms. Law tell what she believed it meant. So please proceed, Ms. Dunlap.
Thank you, Your Honor. So my understanding of avowal, what was told to me that it was an immediate transfer of safety. Mind you, I had been raped on that weekend, and I reported that following day, and Miss Renee had told me that she was going to talk to Christy Neil within that week to see if I could move units or move to the sisterhood or neighborhood,
Okay.
or just to get me moved. That's what
Okay.
was told to me.
So your understanding of this document was that it was needed in order to transfer units inside the property or to a sister property.
Mm-hmm.
Okay. And at the time, in another thing, sorry, Mrs. Law, at the time you turned in this document in April, was the termination date filled out?
No.
Okay. So when you turned this in, the only thing that had happened is it had been signed, or you had signed it and it had dated, but there was no termination date put into it.
There's no termination date. It was just a signature, and the day that, I spoke to Miss Renee, which was 4/29/24, and my unit number. There was no date for me to leave.
Okay. And then my last question for you, Mrs. Law, is on April 29th, I'm going to show you some other paperwork that was produced as part of discovery. Mrs. Law, do you recognize what this is?
Ain't that my statement of after I got raped in my unit?
So if we go back up to the top, it says that, do you see where it says, can you scroll up a little bit? Well, I guess, Mrs. Law, is your understanding that this is paperwork for VAWA?
Yeah, that's all really, like, when I had got the paper, that's really all I seen was VAWA. So when I went up to someone higher than me, which was the property manager at the time, plus the safe line, they had gave me the impression was for me to have an immediate like move, which was to another unit or like somewhere else, but they were going to help me. That was my understanding of a VAWA at the time.
Okay. And we'll talk some more about VAWA later during your direct examination, but for right now, I pass the witness.
Mhm.
All right. Anything else, Mr. Lung, follow up? Or direct, I guess. Redirect.
No, Your Honor.
Okay. Thank you, Ms. Law. I'm going to have you virtually step down from the witness stand. Mr. Lung, who's your next attorney? Or your next witness?
Yes, Your Honor. I call Miss Ebony Davis.
All right. Ms. Davis, if you'll turn on your camera, please, and unmute your microphone.
Hi, I'm unable to get my camera to work. My apologies.
Okay, Ms. Davis. I thought I saw you earlier. Maybe that was Ms. Neil I saw. But go ahead and
Yes,
proceed.
sir.
Go ahead and proceed with questions, Mr. Lung.
Yeah, Miss Davis, you're currently the property manager, correct?
Correct.
Okay. So, Miss Davis, on November the 4th of 2024, can you actually see my screen, Miss Davis? If I share it?
Yes.
Okay. Miss Davis, do you see my screen? Notice a proposed eviction?
I cannot see your screen.
Okay.
Yeah, she's calling in from a phone, but I see there's two different screens. So
Yeah, I'm on my computer in the office and on the phone as well because the camera on the computer doesn't
So,
work.
Miss Law, this is a notice of proposed eviction, correct? You have personally handed this notice to Miss Law.
Yes.
And then you have also, under the knowledge that your attorney, me, have personally mailed it, certified, and regular mail, correct?
Correct.
Now, Miss Davis, on here, it stated 3 causes for eviction. Number 1 is April 29. The landlord received a notice of termination. Number 2 is failure to pay rent from July to now. And number 3 is the threat with Mr. Martinez that we discussed earlier, correct?
Correct.
Okay. All right. Your Honor, I pass to my witness.
No questions for this witness, Your Honor.
all right. So Ms. Davis, you're the current property manager of Lucero?
Yes, sir, I am.
Okay. All right. Thank you.
Thank you.
All right. Can she be excused?
Yes, Your Honor.
Yes,
All
Your
right.
Honor.
Next witness, Mr. Lung.
Yes, Your Honor, I'm going to call Miss Christy Neil.
All right, Ms. Neil, if you'll unmute your microphone and turn on your camera, please.
Miss Neil, can you hear me?
Yes,
Okay. Miss Neil, what is your current position?
I am the regional property manager.
Okay, as the regional property manager, I assume that Lucero is one of your properties.
Yes,
So being overseeing Lucero, you're familiar with the lease and the day-to-day operation of Lucero property, correct?
I am.
Okay. Miss Neil, can you see my screen, the model lease for subsidized program?
Yes,
Now, Miss Neil, this is the lease between the landlord, which is Lucero, and Shakira Law, which is a tenant, correct?
correct.
Okay. Now, Miss Neil, is this a true and correct copy of the lease document?
It is.
Okay. Now, Ms. Neil, under paragraph 23, the landlord may terminate this agreement only for the following reasons. You see that?
Yes, I do.
Okay. And then under subsection 6, you see criminal activity by a tenant, any member or tenant household, a guest or another person. That's correct.
Correct.
Now, 10, landlord meaning Lucero. If the landlord determines the landlord has committed a criminal activity, regardless of conviction occur, you can terminate the lease, correct?
Correct.
Based on what you had heard from Mr. Martinez, you have determined that the tenant has committed a criminal activity, correct?
Yes.
So how do you form that decision? How do you determine that if a criminal activity has happened?
We definitely look at the circumstances. If there has been multiple interactions with the particular resident as far as situations are concerned in incidents that the tenant has
Your
been
Honor,
involved.
I would like to object here. I feel like this question is a way for plaintiff to try to get in irrelevant information, and so we would object on that basis.
Okay, so I'm going to go ahead and sustain the objection. And so limit your answer to what the attorney is asking you, Ms. Neal. Please. I think the question was, you determined that there was criminal activity based on the incident involving Mr. Martinez.
I'm sorry, hearing some feedback. It might be from Miss Davis's audio.
Okay.
I'm not sure.
Would you mute Miss Davis, please? Okay. All right. Next question, Mr. Long, please.
Yes.
Ms. Neal.
Yes, Ms. Neal. And Ms. Neal, go back to paragraph 23C, 23A. The tenant also has the option to terminate by giving you a 30-day notice to move out, correct?
Yes.
Now, Ms. Neal, it is my understanding you had a meeting with Ms. Law regarding the notices that she submitted with you, correct?
Yes. I'm actually on site on another property, and so I'm in an office, so that may be the background noise in the phone, so I'll mute in between.
Okay. Now, Ms. Neal, in that, and you were during that meeting, you and Ms. Law has agreed to
Objection, leading.
Let's overrule the objection. Let's get to the part of this, Mr. Long. Go ahead and ask your question, but
yes.
try not to be try not to do it in leading questions.
Ms. Neal, you have Ms. Law has mutually agreed to terminate the lease on August 22 of 2024, correct?
Yes.
And then you have received that notice, the 30-day notice termination, and then you wrote August 22 on the
Objection, Your Honor, leading.
Your Honor, I'm asking who wrote the August 22. That is a leading question, but that's the only way I can ask it.
So what was your question, Mr. Long?
Who wrote the date of termination on the notice?
I don't know there was a date of termination on the notice. Was there?
Your Honor, I'm about to submit that.
Okay.
Okay, Ms. Neal.
So who wrote the date of termination on? Is there a date of termination on a notice?
Yes. Ms. Neil, you see this document on my screen?
Yes,
That's the same 30-day notice to vacate that the property received from Ms. Law, correct?
yes,
But on here, August 22nd, the termination date, you wrote this down, correct?
yes,
Because you wrote here, it's received by you, Ms. Christy Neil, on July 22nd at 5:24 p.m., correct?
correct.
Now, Ms. Neil, you wrote this in front of Ms. Law, correct?
Yes, along with the owner of Lucero, Will Campos, was present.
Did she agree to that date during the meeting?
Yes, she did.
Okay. Your Honor, has passed my witness.
Ms. Dunlap or Ms. Goldstein, who's going to ask her questions?
I will, Your Honor. Ms. Neil, can you state your full legal name?
My first name is Ebony. Middle name is Christy, last name is Neil.
Okay. You're a regional manager for Eureka, correct?
Yes,
And Eureka manages Lucero Apartments, right?
yes,
How long have you been employed by Eureka?
3 years.
Okay. Lucero Apartments participates in the low-income housing tax credit program, correct?
Yes,
And Lucero also participates in the Section 8 project-based rental assistance program, correct?
yes,
Okay. And so as part of those programs, you're subject to state and federal rules about VAWA, or the Violence Against Women Act, right?
yes, ma'am.
What's your understanding of VAWA?
My understanding,
Relevant. Objection?
What's the object? I mean, it's what she understands it to be. So I'm not saying she's she's not being qualified as an expert. Is that correct, Ms.
Correct.
Goldstein?
Not qualified as an expert, and Your Honor, we didn't bring up anything regarding VAWA. She can call Ms. Neil in the case in chief, but as far as cross-examination, I don't think this is subject matter of her testimony.
I'm going to go ahead and allow it so we can, because either we call her now or we're going to call her later. So let's go ahead and get this crossed and done as if it was her in their case in chief. But so what's your understanding then, Ms. Neil, of ask directly what your question is, Ms. Goldstein?
What is your understanding of the purpose of VAWA?
the purpose of VAWA is a domestic violence. If you have a resident that has been involved in a domestic situation, or assaulted or any criminal activity of that matter, that they can either, if they're saying their life is in danger, we have to relocate them. They can either relocate to a sister property, or we have to allow them out of their lease with no penalties, so they can relocate to another location, apartment, so that they feel safe. And we have to do that in a swift manner, so that the resident is not in danger.
Okay, if a person wishes to exercise their rights under VAWA, they would submit a VAWA certification, right?
Yes.
Okay, I briefly want to show you what one of those look like. I know we talked about it before, so I won't belabor this, but I'm just going to share my screen. And this is the same notice of proposed eviction that your counsel brought up earlier. I'm turning to these VAWA forms at the end. I'm sorry, I'm going kind of quickly. This is the notice of occupancy rights under the Violence Against Women Act, correct?
Yes.
And this is a certification of domestic violence under VAWA, correct?
Yes.
And so the tenant would put their name, the name of the person who abused them or assaulted them, where it happened, and what exactly happened, right?
Yes, that's sent out by our attorney.
Okay. And there's no lease termination that's generally included in this packet, right?
What do you mean?
This packet that your attorney gives to tenants that specifies their VAWA rights and has the form for them to fill out, there's no form that says this is a notice to terminate my lease, correct?
Correct.
And then I want to show you again that same termination notice that Mr. Long showed you a moment ago. Sorry, I just have to share my screen again. So this is the notice to vacate that you filled out the date in for Miss Law, correct?
Correct.
And anywhere on this notice, does it mention the Violence Against Women Act?
That was not about the VAWA.
So this,
At this particular day when we were talking on July, it was not in regards to the VAWA.
okay. When you receive a VAWA certification similar to the one that I just showed you, what is your process?
So if when a resident comes in and requests a VAWA, we immediately, if we have availability on the property, we will transfer. She at that time stated, Ms. Law, that she did not feel comfortable being on the property. I offered to transfer her to a sister property, which when I got the availability and spoke to the manager there, we had 100% occupancy. There was no availability. I then let her know that we would let her out of her lease with no penalties as long as she left the unit nice and clean. And that's when she agreed to that. And she did say, well, I don't have anywhere to go because I don't have anywhere for me and my children to go. And I told her that there's a lot of resources out here. She wanted us to find her somewhere to transfer to, and we don't do that.
Okay. Do you have an internal wait list for units at Lucero for people who wish to transfer internally?
Yes. Well, if we have a waiting list, period, it's not internal. If they are overhoused, they go on the wait list for a 2-bedroom. If they that's really the only reason why we transfer, or if they're ADA, they need a handicap accessible unit. We don't just transfer because you want to change units. The wait list there is anywhere from 3 to 5 years.
You give the same priority for VAWA tenants who submit a certification and say, I want to transfer to another unit at the property?
I can't say yes or no. We have not done that in the past because VAWA is not something we deal with every day.
Okay. So you're aware that Miss Law reported to management in April that she was raped in her apartment, right?
I was not. I was not aware that she had bought that into Renee. I was not aware of that until Shakira Law called and left me a voicemail in June when there was an incident that was tied to her mother's unit and her unit of another young man that had.
Objection, asked and answered. So,
Okay, well, I
It's
was not aware until June.
okay. I'm going to show you a document here. This document was provided by your counsel in discovery. It says Eureka Incident Report. It says date of incident 4/27, property manager Renee Cole, regional manager Christy Neil. And it talks about Miss Law came into my office and reported to me on 4/27 that she was sexually assaulted in her apartment. See, have you seen this document before?
I have not. I was out due to my daughter. I lost my daughter in April of that year. So I am listed on the incident reports because that's part of when they fill out. But I was actually out of work for about a month and a half due to that. So I did not see that incident report.
Okay. Your Honor, we would move to admit this incident report as Exhibit 4.
For what purpose, counsel?
For the purpose of showing that Miss Law came to the office and reported her assault and spoke with the property manager. And we believe this is relevant because she will testify that she turned in a VAWA certification on that same date.
All right. That's admitted.
Miss Neal, you met with Miss Law in July 2024, correct?
Correct.
And you discussed her request for a transfer under VAWA during that meeting, correct?
Yes, and the owner was present. I just want to make sure we note that Will Campos was present.
Okay. You had spoken to Ms. Law about a transfer prior to that meeting, right?
Yes,
And you told her that Lucero was 100% occupied, right?
yes,
And you did not put her on an internal wait list for a transfer at Lucero.
no, I did not.
Okay. And now I want to talk to you a little bit about that meeting with Ms. Law on July 22nd, 2024. You're aware that meeting was recorded, right?
I was not.
Okay. But you told Ms. Law you were recording that meeting, didn't you?
That I was recording?
Yes.
I don't recall.
Okay. I'm gonna play part of that. Let me just take a second to get it loaded on my screen here. And please let me know if you have any issues with the audio, but I'm going to play it and hopefully it should work well.
Let me explain to you how a vowel works, okay? And I'm recording this, so we have it on recording.
Me
With a
too.
vowel, once you file.
Miss Neal, so you say I'm recording this, so we have it on recording, correct?
Yes,
And she says me too, and she being Miss Law?
yes.
Okay. Your Honor, we would move to admit 3 recordings from that meeting that are all in the link we provided to the court ahead of trial, and I'm going to be playing clips of those recordings as well. We also provided these to counsel last week.
All right. Any objection, Mr. Long?
Your Honor, no, I've seen all the videos.
All right. Let's admit it. Go ahead and do you have questions to ask from those recordings, Ms. Goldstein or Ms. Dunlap?
Yes. So, Ms. Neal, during your meeting with Ms. Law, you told her she'd be getting a 3-day notice to vacate, right?
Yes.
Okay.
And it was not pertaining to the VAWA. It was pertaining to another situation
And that was
had
for
occurred.
it was for the argument with Steven, right?
No, it was actually regarding another incident with a young man. I can't remember the other resident's name, but there was a shooting that happened on property. And the young man was,
We would object as to relevance. This is not listed in the
well,
petition.
you asked me why I was given the 3-day. I gave her mother one and her one
Okay.
because of
Ms. Neal,
another shooting.
I'm going to play a bit of this recording for you now.
That's Steven's point of view.
So at this point, Ms. Neal, you're watching that video that the court watched with the argument with Ms. Law and Steven, correct?
Yes,
Okay.
yes.
Come over here and kill you. And then you say it more than once. Then your boyfriend shows up with a gun.
He didn't have a gun.
Ooh. Okay, several people, and I have 6 statements.
And so, Ms. Neal, you are talking about the incident with Ms. Law and Steven, right?
I am talking about the incident where the young man came and actually shot up the property.
Ms. Neal, you're playing the video of her argument with Steven, and you are talking about an alleged threat that you believe Ms. Law made, correct?
Yes, and then this occurred a few days later.
Ms. Neal, it's a yes or no question.
Judge, objection is relevant. I'm not sure where his defense counsel is going.
Your Honor, I'll move on at this point. So we established that you told Ms. Law she'd be getting a 3-day notice to vacate. During this meeting, you also pointed out that Ms. Law was drinking the night she was raped, right?
Yes,
Objection relevant?
yes, that's what she said. Yes, and that was the statement Ms. Law told us.
Your Honor, I think the entire content of this meeting is relevant. This is the meeting where they are saying that she provided her notice that she wanted to leave willingly, but we're arguing that a whole lot happened at that meeting to pressure Ms. Law. This is critical to our defense.
All right.
Okay.
On the overruling objection, continue, please, Ms. Goldstein.
I'm going to play you a little bit more of that recording.
To HUD. And as far as the bottle situation with you, I think I spoke to you about the incident that you said you were raped in your unit when you came in, and to find out that you were drinking at another neighbor's house. Okay.
At my friend's house.
Okay.
That I was in their care. I don't know that man. They didn't know that man. So why you let a man into my unit and I was in your care?
What you told me when you came in, you didn't say anybody let someone into your unit.
Yes, I did. I told Miss Renee too.
No, excuse me. I'm gonna ask you to step out in a minute. Okay. I'm allowing you to be in here. But me and your daughter have a conversation that you were not here for. And that's why I'm asking you to please be quiet.
Yes, ma'am.
She came in and talked to me with Rhonda.
Oh, okay.
Okay. And not one time did you tell me someone let him into your unit.
Yeah,
Okay,
Zayna and
listen to what
Brisha.
you told me. Okay. You did not tell me that. What you told me is that you and a young man went to your unit and you were drunk and you fell asleep. And when you woke up, he was on top of you. That is what you said. She was in the office
I
when
did
I was
it, but
talking
no.
to you. Okay, that's the story you gave me. Now, if your story has now changed,
It haven't. It's been like that
and
since
then
the
I
police
asked you, I
repeat.
said,
Ms. Neal, you accuse Ms. Law of changing her story, right?
I didn't accuse her. It's actually what she said. She
Okay.
did change her story.
Okay.
you never asked about Avala.
No, but I did.
Okay, when you
I talked to Miss
when you talked to
Renee.
me, you never asked about Avala.
Because I didn't know nothing about it. Miss Renee told me about it. I said, what is about? She walked me through the steps and then she put the date. She walked me through the whole thing. And then Ty told her that I never came up with about. I said, yes, I do, because I got the papers with me.
Okay, we never received those papers here in the office.
Yeah,
That's
Miss.
one. And two, when you came to talk to me, I
It's
offered to let you out of your lease because what I told you, listen, look at me.
Ma'am, I'm getting kind of upset because it's
You
just
shouldn't be, because we're just gonna tell the truth.
That's no, because you remember I told Miss Cheryl, I said I kept coming up here asking, can I move my, she said, no, the best
So
thing,
what I told you,
no, she said the best thing I could do is move out of these apartments because they're gonna find
we're
you.
100% occupied. That's the same thing I
No,
told
but
you.
I told you I will wait.
Let you out of your lease.
Ms. Neal, she's saying to you, I will wait for another unit at Lucero, right?
Your Honor, objection, that's out of context.
No. And based on what she was telling me is that she felt threatened because this young man that she says assaulted her. I do want to put on record that I never heard that he was arrested or locked up because he's still at Lucero. He's still living with his mother.
Okay.
And there was
Ms.
nothing
Neal, I think you've answered my question. Thank you. I'm just going to play a little bit more of this.
With no penalties.
But I just
And
wanted
you
to
will
move
have to move
unit.
some. But we're 100%.
But I said I was gonna wait.
So with Avala, let me explain to you how Avala works, okay? And I'm recording this, so we have it on recording.
Me
With
too.
Avala, once you file it, that means that you are saying you are in immediate danger.
I
That you
was.
have to move out of your unit and that you need to find a
Because
safe
Miss
place.
Renee promised me another unit.
But
That's what.
that we don't have.
But
it.
I didn't know that.
But I told you that.
No,
And
but
you
days
talked to Renee
prior.
After.
No.
So, okay,
I didn't
but
talk to
even
you first.
if you say days after, okay? You talked to Renee, and then days after you came and talked to me. Okay, I'll give you that. When I talked to you, I told you, we don't have anywhere. We are 100% occupied. We don't have any vacant units that we can transfer you to. I said, but what I will do for you is I will let you out of your lease with no penalties and let you move off the property.
Yes, ma'am.
I said, you will need to make sure that your unit is clean.
Yes,
If
ma'am.
my life is in danger
Yes,
and
ma'am.
I don't feel safe,
But I don't have nowhere to go.
Okay, Ms. Neal. So you say to Ms. Law that a VAWA is a request to transfer off the property, right?
Yeah, where else was she gonna go? We are 100% occupied, and she made it clear that she felt like her life was in immediate danger.
And Ms. Neal, you did not offer to put her on a wait list, right?
The wait list is 3 to 5 years.
Okay. And you're saying that she submits a VAWA certification because it means that her life is in danger, right?
Well, when you submit a VAWA, you're saying that you don't feel safe, that you have been assaulted, or there has been a domestic issue that has taken place, and that you are seeking safety. That is what the VAWA is, a Violence Against Women's Act.
Is it your belief that in order to qualify for a transfer under VAWA, Ms. Law would have had to say that she believed her life was in immediate danger?
I don't know how to answer that question. She had said that several times. I'm not putting words in her mouth. She made that statement more than once, that her life was in immediate danger.
Okay, I'm going to show you another document. This is titled VAWA Protections. It's under HUD's Code of Federal Regulations.
Can you give me one moment? I don't mean to cut you off. My battery on my laptop is about to die. I need to grab my charger right quick. One moment. I don't want it to die.
And Your Honor, I really object to this line of questioning. I know she's questioning if my client understands VAWA, but she's not an expert in the VAWA law. I'm not sure where this is going. If they want a VAWA defense, they need to question Mrs. Law.
Your Honor, we believe that, the VAWA regulations here are relevant because Ms. Neal explained her belief about them to Ms. Law in this meeting.
All right, you can proceed, Ms. Goldstein.
Okay, Ms. Neal, are you back and
yes,
everything's good? Okay, I'm gonna scroll down. Just give me 1 second. I'm gonna scroll down to section E, which I have highlighted. It's titled Emergency Transfer Plan. Each covered housing provider shall adopt an emergency transfer plan. And then section 2, the emergency transfer plan must provide that a tenant receiving rental assistance through or residing in a unit subsidized under a covered housing program, excuse me, who is a victim of domestic violence, dating violence, sexual assault, or stalking qualifies for an emergency transfer if the tenant expressly requests the transfer and either the tenant reasonably believes there's a threat of imminent harm, or in the case of a tenant who is a victim of sexual assault, either the tenant reasonably believes there's a threat of imminent harm, or the sexual assault occurred on the premises during the 90-day calendar day period preceding the date of the request for transfer. Did I read that correctly?
Mm-hmm.
The only reason we go for the throat is love. Did I read that right?
You did.
And then she writes, my throat is yours. And then you write, I have other uses for your throat which do not include injury.
Sorry, could you read that again?
To your words, sir, right?
And you tell Ms. Law normally on the VAWA that you do not transfer within the property. Is that right?
You said I told her that?
Yes.
I don't know if I told her that or not. If you're saying I did, I did.
Okay. Is that your belief about VAWA?
You can transfer them on the property. You can transfer them off the property. You can transfer them to a sister site. We did not have any unit availability, and we still don't. We're 100% occupied.
Okay.
Let me take that back. There is one unit on the property that is considered a set aside that is not subsidized housing because Lucero has 12 market units, which are conventional market rate.
I think you've answered my question. I just want to briefly go to section 5 of that same section about emergency transfers. The emergency transfer plan must allow a tenant to make an internal emergency transfer when a safe unit is immediately available. And the emergency transfer plan must describe policies for assisting a tenant in making an internal emergency transfer under VAWA when a safe unit is not immediately available. And these policies must ensure that requests for internal emergency transfers under VAWA receive, at minimum, any applicable additional priority that housing providers may already provide to other types of emergency transfer requests. Did I read that correctly?
Mm-hmm.
Okay, so this means that you must give a VAWA tenant who requests an internal transfer the same priority as someone who is requesting an accessible unit, for example, right?
Yes, we have not had one.
You have not had one what?
We have not had any unit availability.
Okay, I want to play you a little bit more of that video.
Is in danger that you transfer the property. This young lady was in an abusive relationship with her baby daddy, and we transferred her from one unit to another unit because she didn't want him to know. Well, I mean, all he got to do is sit and watch her, and watch where she walked to, and watch where she parked the car. He killed her.
So in this
There-
clip, Ms. Neal, you're telling Ms. Law about a story about another tenant in one of your properties who requested an emergency transfer. Her abuser found out where she lived and he killed her, correct?
Absolutely, I did share that because it happened in real life. Yes.
Okay. And Ms. Law's mother, Fannie Harrell, was also present during this meeting that was recorded, correct?
Yes.
Okay. And Ms. Law's mother, Fannie Harrell, also lives at Lucero Apartments, right?
Yes.
And you threatened to evict her during that meeting, right?
She got a 3-day notice for the shooting that occurred on the property because he was tied to her unit as well.
Okay,
Your Honor, objection relevant.
Your Honor, this all goes to the coercion of Ms. Law to try to push her out of the property. We've already admitted these videos. I'm sorry?
Overrule
Did
the
she share?
proceedings.
Did Ms. Farrell share the 3-day notice, a copy of the 3-day
Ms.
notice?
Neal, please do not speak unless you are asked a question specifically.
What's your next question, Ms. Goldstein?
I'm just pulling up audio.
Guess what I gotta do? Because if I evict you, guess what you're gonna do? Move right in with her. And so then guess what? She got to get her 3-day because she's out there with you. She's seen on these cameras, and you put your mother in a bad position. But I didn't mean to.
So, Ms. Neal, you say that if Ms. Law is evicted, she will move in with her mother, and so her mother needs to be evicted as well, right?
Yes, community house rules and the lease, you cannot have an unauthorized occupant who is not on the 5-9, who has not properly applied for the unit. Absolutely, that is a violation of HUD.
Okay, and you gave Ms. Law's mother, Fannie Harrell, a lease violation that day as well, right?
For the shooting, because the several residents identified her
Ms. Neal,
unit.
it's a yes or no question.
I did not, okay, well, no, I did not for the VAWA.
Did you give her any lease violation on that day, yes or no?
No
I
objection.
did for a shooting that occurred and her unit was tied to it.
Okay, I just briefly want to show you this lease violation. So this is a notice of lease violation to Fannie Harrell. It's dated 7/22/23, but you gave it to her on July 24th, correct? Sorry, July 22nd of 2024, correct?
That is not, can you go to my signature?
Can you make it a little bit bigger, please? I can't, it's harder to see that.
Yes. Yep, she was involved in a shooting. That
Okay,
has nothing to do with the
It's
VAWA.
the only violation that is listed in this notice, I'm scrolling through slowly, says this serves as your only and final notice that you are not allowed to house your daughter, Shakira Law, under any circumstance. If it is brought to management's attention that she has visited your unit, you will be given a 10-day NT, I think that's supposed to be NTV, no exceptions. This is the only warning you will receive should you or any guest be involved in any incident on property. There's no mention of a shooting, correct?
Well, that's what I'm letting you know. That's what it was for. Her daughter was already under
Ms. Neal,
eviction, and that was
Neal,
in regards to the shooting. And we
Ms.
wanted
Neal,
to make
yes
sure
or
we
no question?
documented that.
Okay.
It's not listed on that violation. Is that correct, Ms. Neal?
As the shooting that occurred?
It's not written on that notice. But that's what
No. But that was the context of the meeting and the conversation with the mother.
Okay, I'm almost done here. I just want to play a few more clips of these videos. This is a different file.
This is being clear. I'm asking you, are you saying that your life is no longer in danger?
Well,
and you don't want to move forward with the Bible? That's very cut and dry.
Will I be able to stay though?
That's not the question we're asking. The question is, are you saying your life is no longer in danger and you don't want to move forward with the Bible?
I'll just move forward with it.
Okay.
And Ms. Neal, when you say move forward with the VAWA, you mean that lease termination notice we talked about earlier, right?
That lease termination was done in April. I hadn't even talked to her till July. So what she turned in April, I didn't even know anything about that.
But Ms. Neal, you filled in a date on that lease termination notice
On this day, when she bought it back to me, I never saw it in April.
But you're
I didn't know
referring
anything
to
about it.
Ms. Neal, you're referring to that lease termination as a VAWA, correct?
No, I'm referring to the VAWA, the paperwork that she came in there and bought in July. She called the owner and asked the owner to come over and speak to her.
Ms.
He
Neal,
came over
Ms. Neal,
with us, and
maybe I
that's
should
when that
rephrase
occurred.
my question. So you're saying, are you going to do the VAWA? What does that mean?
No, what I said is, are you telling me your life is no longer in danger?
Okay.
And if that's what you're saying, then we have another situation we need to deal with.
Okay, Ms. Neal, then I will, I'm going to play a little bit more of this.
So I'm going to let her know that.
I'll just move forward with it.
Okay.
I'll just move forward with it.
And your life is no longer in danger and you don't want to move forward with the Bible.
You're saying move forward with the VAWA. I just want to understand what you mean by that.
Right. At the very beginning of the clip, in the conversation you played, we were talking about the VAWA on this day. There was nothing, I had never talked to her prior to this day. I didn't talk to her in
Non-responsive. Ms. Neal, I just want to understand what you mean by move forward with the VAWA.
If she was stating her life was no longer in danger, there is no
Objection
VAWA.
non-responsive. Your Honor, I think it's a simple question. I just want to understand what she means when she says move forward with the VAWA.
This is my answer, Ms. Goldstein. If she said her life was no longer in danger, there was no need to file a VAWA. That is my answer.
And what does it mean to file a VAWA?
You asked me that.
Okay.
At the very beginning, you asked me what my understanding to a VAWA was.
Okay, I'm gonna keep playing this.
I'll just move forward with it.
Okay. So I'm going to let her know that you want to move forward with the VAWA, and we're going to give you 30 days from today, 8/22, and I'm going to.
So you're saying we're gonna move forward with the VAWA, and I'm going to give you 30 days to move out. Is that right?
Correct, because she said she didn't have anywhere to go.
Okay.
Put it in writing that we're not going to give you any.
I feel like I'm pressured, so like, yeah.
And she says, I feel like I'm pressured, right?
I guess that's what she said. She mumbled. I don't know what she said.
Okay.
You're pressured. Either your life is in danger or your life is not.
No, because if I say no, because I need this place for my kids, I feel like you're gonna do something.
But that's okay. So you're saying yes, your life is in danger, but you want to stay here because you need a place to stay.
For my babies.
Okay. Unfortunately, a VAWA does not work like that.
So if I just cut the VAWA, would I be able to stay here with my babies? That's what I'm saying.
You are stating that your life is in danger.
Okay, I'm just going to play a few more seconds of this clip.
It's like a waiting.
So if I say no, it's an eviction and it's a 30-day.
Literally.
What?
If I say no, my life is not in danger, it's an eviction and it's 30 days.
If you say no, your life is not in danger and you don't want to move forward with the VAWA, there's not I think what you're trying to do is find a way to stay here, okay? And that's not what we're here to discuss. A vow is a very serious matter, very, very serious. Okay, it is for people who are genuine.
Just go ahead with the vow.
Okay, so with that, I'm gonna put in writing in a notice to you and to HUD to say that, listen, we are going to honor your vow. I need you to bring me that form that you dated, because we don't have it here. There's nowhere in your property. I'm going to go ahead and process that. You will have 30 days from today. This is our compliance. She's going to go ahead and get started on that. If you need a rental verification, if you're going to apply from somewhere, and with the VAWA, you can take that somewhere and they will put you first on the list, right? Because you're considered the emergency. You can go to HACA, which is the housing authority here. Possibly you can get a voucher. Maybe you can go to a woman's shelter. I'm not too familiar with Austin.
So you tell her that she could take her VAWA certification and get first priority at a housing authority of the city of Austin property, right?
Or immediate move, yes, because our wait list is 3 to 5 years. Yes, ma'am, I did.
She would not get priority on your wait list because she has her VAWA certification?
Well, we didn't have any notice to vacate. Nobody was moving. There was no availability. We didn't even have a unit in the pipeline coming available.
Ms. Neil, that's
for her.
not my question. My question is why couldn't you put her first on the wait list for when a unit did become available?
Because she said her life was in immediate danger.
Okay, I promise I just have one more short clip of a different video and a few more questions, and then we'll move on after that.
We don't have anything that could you provide me showing that management has received it or a confirmation.
But she said that she was going to give it to y'all. That was what was told for me before Miss Renee left. She said all my paperwork, she's going to give it to the boss. She said I shouldn't have to go through y'all. She said she was going to go through y'all herself.
So I'm not denying it. So what I am saying is that, give me a moment, please. Give me a moment. Oh, my God. And so what I am saying, go ahead and lock the door for me. What I am saying is that I'm going to honor that. But with honoring that, there is nowhere to transfer you. But we are going to go ahead and let you out of your lease. And we're going to go ahead and let you, with no penalties, move off the property. Okay? There is nowhere to transfer you here. We don't have anything. And even at our sisters. And yeah, so it won't mess up your credit. You can go somewhere and that you can get another apartment. We at our sister property, we're 100% occupied there. So transferring you there would have been a possibility, but we don't have anything available there. And that's at our sister property.
So me and my kids are supposed to be homeless on the street within 3 days.
I wouldn't say homeless. What I'm saying is that we are giving you the opportunity. It won't be a 6-month time frame where you can just stay there for 6 months. And, again, you have stated not only to myself right now, you have stated to HUD that your life is in danger, that you feel like your life is in danger. That's what the VAWA is, Violence Against Women's Act.
Okay, didn't y'all have security patrolling that area though?
Security is not here for the safety of the residents. The security is here to protect the asset of the owners, as well as the gates. That's not a protection. We can't promise you protection because we have security. Police can't promise you that.
So if I get the footage of Steven coming down the elevator, cussing me the fuck out, I can stay in my unit.
No, you have filed a VAWA. You have filed that your life is in danger.
So that was months ago and is now coming up in my eviction.
Yes, and you just sent it to HUD Friday.
Yeah,
saying that your life is in danger, and that's exactly what they put in writing to me. And so now that I'm aware, I wasn't aware of a VAWA that was filed, but now that you're telling me that you feel like your life is in danger, this individual is still walking around the property, so now I need to find out. I know who the mother is of this individual.
Why can't y'all just stop him from just walking around the property?
You know how many people I've told not to come back? And this property is big. I can't sit here and babysit the property. That's not a realistic and or a reasonable accommodation.
Let this rapist go around, because I'm not the only female.
Right, and that's why I'm saying I'm going to enforce your VAWA. And I'm going to, because the sense of urgency
With that vow, how long will she have to move?
Well,
3 days, because it's an act. Because remember that lady told us. Within
It'll be 3 days.
no 3 is 30.
So altogether it's 30 days. Okay.
So we'll go ahead and notate it. I will reach out to HUD and let them know there is no paperwork.
There's no legal aid or something like this or anything.
What do you mean, a legal aid for what?
This whole situation.
Yeah, you can reach out to legal aid, but you're the one that initiated the.
No, but that was like, it's weird that it's coming in my eviction. Now y'all
You
force.
just sent that paperwork.
Yeah, but
to
now it's
HUD.
giving y'all a reason to force the eviction or send me out. When I sent this months ago, when Miss
Okay,
Renee
we don't have it, and the first time I'm hearing about or seeing about it is Friday when you sent the paperwork, and you just sent a picture of the
I
package.
remember
But
my daughter did come up. I told her to bring this up there to the office.
and that's even more reason why we need to put it in gear, because again, your life is first. You can't say my life is in danger. I don't feel comfortable.
So Ms. Neil, during this video, you talk about how Ms. Law complained to HUD. By that, I believe you mean Southwest Housing Compliance Corporation, right?
Yes.
Okay.
And we had never seen the paperwork. She actually, the paperwork that she said she took.
It's a yes or no question. I'm going to show you an email that you sent to Southwest Housing. And this is an email you sent to Southwest Housing, the shcc.net, that we've redacted just because we're focused on this one paragraph here where you write, and do
You
you
should show
recognize,
the whole email.
do you recognize this email?
Not with it redacted, I don't.
Well, did you write these words? Regarding the sexual assault, Miss Law was at another resident's apartment, drinking alcohol and driving with the resident, and this unknown guy, Miss Law, invited him into her apartment. I investigated this complaint and spoke with the resident who was drinking with Miss Law. Once the unknown guy had the sexual encounter with Miss Law, he left the unit, enraged Miss Law, and she stated it was sexual assault. Did you write those words?
If that came from my email, you redacted the email, so I'm not sure. I wish we could see the entire email.
You do not remember writing this email? Miss Law, is this your email address, kneil@eurekamg.com?
That is my email. And so as I stated, you have redacted a good portion of the email. So I think it's relevant that the whole email be shared.
Okay. And then I'm just going to show you one other document and then wrap up. This is a certification of domestic violence, dating violence, sexual assault, or stalking that was submitted by Miss Law through me to your counsel on January 2nd, 2025. We've already seen this before because Mr. Long has presented it. At the end, Miss Law asked to retract the 30-day notice to vacate for a victim of sexual assault that Lucero apartment says I submitted. Excuse me. Have you seen this VAWA certification?
If Mr. Long sent it to me,
Honor,
I got
objection. Relevant.
Your Honor, I believe it's relevant whether or not they responded to this VAWA certification and her retraction of her, what they believe was a notice of termination.
Your Honor, this is no longer relevant because under VAWA, as counsel said, it has to be 90 days prior. Incident is April. This is January. That's way over 6 months.
I'm not familiar with the requirement that it be 90 days.
You just read it to me.
You just read it.
Talking about if you don't feel that your life is in danger, you can submit a VAWA certification within 90 days of sexual assault, but that is not a requirement to submit a VAWA certification in general.
I'm going to overrule the objection, Mr. Long. Continue, Ms. Goldstein.
Ms. Neil, have you seen this VAWA certification?
I have not. I have over 400 emails because I just got back from vacation, so I'm trying to comb through those. I'm not saying I didn't receive it. I just have not got all through all my emails.
So to your knowledge, have you, granted these requests pursuant to VAWA?
If I haven't seen it, I can't request, if I haven't seen it, I can't act on it. I just got back Monday, this Monday from vacation.
Okay, Ms. Law, or I'm sorry, Ms. Neal, I have no further questions.
All right, thank you, Ms. Neal. Your attorney may have a few follow-up questions.
Yes.
Or, redirect.
Ms. Neal, you saw on my screen the email.
Yes.
This is an email that was the part that was redacted. You told Southwest Housing that Ms. Law has
Your
not.
Honor, this is hearsay. We would object to this email coming in.
Your Honor, this is the exact same email that was offered by Ms. Goldstein.
We redacted the email and they did not object to us offering this as a party statement.
You're only going to authenticate this document?
Honor, authentication is not hearsay. That is a completely different rule of evidence.
Right.
Proceed, Mr. Lung. I'm going to overrule your objection, Ms. Goldstein.
Okay. Ms. Law, the redacted portion here, number one, you recognize this is your email address, K. Neil,
yes.
Eureka? This portion,
Yes.
Ms. Law has not come into the office requesting a VAWA transfer. This is your
Correct.
Word, correct? Yeah. And
Correct, because there was not,
and this email stated that you responded to Southwest Housing to complain regarding the gun incident and contacted her boyfriend to come to the property with a gun to threaten and assault another individual, correct?
correct, yes.
Objection. We would again object to this being hearsay. There has been no testimony that her boyfriend came to the property with a gun.
Ms. Neal, could it be possible?
Okay, I'm going to go sustain the objection. It is hearsay. I know that we're allowed to have some hearsay stability in JP court, but that's not in evidence anywhere else except for that statement. So I'm going to go ahead and sustain her objection.
And Ms. Neal, isn't it true that the Southwest complaint from Southwest Housing, it was rendered in your favor?
Correct, all three.
Okay. Now, Ms. Neal, during that meeting, you received two documents from Ms. Law. One being a 30-day notice of termination, and two being the VAWA transfer request.
Object to leading, Your Honor.
Your Honor, cross-examine, I can use leading questions.
Continue, please, Mr. Long.
Yeah.
Overrule the objection.
Yeah. So, Ms. Neal, you received two documents. One is the VAWA request of transfer, and the other document is the 30 days notice of termination, correct?
Yes.
Okay. And then at any time during the meeting, you have physically threatened to Ms. Law to sign off or to agree to vacate on August the 22nd?
No.
And it stated earlier in the video that she said, I'm going to go ahead and move forward.
Yes.
And then she didn't say she didn't want to move forward with the 30 days termination notice.
Correct.
And it is your understanding after August 22nd, the lease between the parties are terminated.
Yes.
Now, Ms. Neal, it was asked earlier regarding the notice to vacate that the mother received. And then you mentioned there is a more shooting incident regarding.
Objection. This is not in the petition. This is not in the termination notice. We've been over this.
Sustained.
Okay. Then, Your Honor, I pass the witness.
No further questions.
All right. Now it's now 4:15. How much longer do we have on your case, Ms. Goldstein?
We just have Ms. Law. I'm not sure why my audio is doing that, but we just have Ms. Law and Ms. Harrell. We don't think it will take much more than 30 minutes to ask them both questions, and then our closing is relatively brief as well. We should be finished by 5.
Okay, I've had something else at 4 o'clock today, and I have something else at 4:30. And so starting at 2 o'clock, I did not realize this was gonna go more than 2 hours long. I'm gonna take a brief recess and assess if I can reset some stuff real quick. So let's do a 5-minute recess, go to the restroom, we'll come back shortly, okay?
Okay.
Thank you, Your Honor.
Thank you. All right, we can get everybody back on screen, please. Mr. Long, Ms. Goldstein, Ms. Law. I need to wrap this up by 4:30. So Ms. Goldstein, you have Ms. Law that you wanted to ask questions of?
Your Honor, we're not going to be able, sorry, we're not going to be able to do our case in chief in 10 minutes, I don't think.
Okay.
We can definitely, sorry, we can keep it, we've already looked at trying to condense it some, but I just don't think 10 minutes is going to be possible, especially with closing.
My concern, based on the petitioner's arguments on their petition regarding their 3 bases for eviction. Number 1, the lease termination of August 22nd. I think there was a misunderstanding, miscommunication, misinterpretation of what that meant. So I'm not inclined to grant the eviction based on that, Mr. Long. The other one, that the defendant threatened to kill another resident or the apartment. I'm not really, it looks like criminal activity. However, I'm not real convinced with the witness that you have or the evidence that you have that is occurred as he has stated it occurred. Okay. The other one, the last basis is failure to pay rent. Has the defendant offered rent and the apartments have refused it?
Your Honor, she offered in June and July, but she did not offer from August to January.
There's no requirement by her after it's been refused more than one time for her to continue to go back, take out the money order. You have to wait like 30 days to get your money back after that. She tried, she made multiple attempts, and they're not contesting that she tried to pay rent several times and that they refused it. And Your Honor, we would argue that they are breaching first by refusing the rent. They can't claim that, she's committing non-payment when they're not accepting it. And we can do we can put her on direct very quickly to get her to testify that she can pay every single dollar of rent that they're claiming that she owes today.
And Your Honor, we didn't have any testimony regarding non-payment of rent, but we agree it's not really relevant. And to just address your concern, there could be a misunderstanding, as defendant counsel has stated, but she acknowledged that she could turn in the 30-day notice of termination. And now she's trying to retract the notice because of her misunderstanding. She acknowledged she signed it, it was turned in, it stated 30 days, the lease was terminated. And she cannot unilaterally say, I retract, and then VAWA does not allow her to reinstate the lease. VAWA protection is to transfer when there's unit available, put it on the wait list. But when she submitted both forms, a 30-day termination under Texas Property Code for sexual assault without a VAWA, and you subsequently submitted a VAWA that doesn't waive the notice of termination that was submitted previously, that she testified she did. She submitted both. Yes, she's entitled to VAWA protection to transfer, but at the same time, you cannot ignore that she also submitted a 30-day termination notice to terminate the lease. And as she testified, she did it herself. She understood what it was. And then she stated she didn't move, but now she's trying to come back, say she can move, to retract the notice because she cannot move.
Your Honor, if I may.
I felt she was pressured on that. Yes, Ms. Dunlap.
I was just going to say, I think that there's clear-cut duress in the situation. Several times she said, I don't want to do this, that I feel pressured. They gave her a lease violation of her mom in front of her, and told her that, and misrepresented what VAWA stands for. So I think there was coercion. In addition, I think another major issue with plaintiff's case is that and it's uncontroverted, it was on the video that Mrs. Law did not date that herself. She did not turn, for a tenant to turn
I understand. I saw that.
Yes, Your Honor.
So, Mr. Long, I know you are zealously advocating for your client, but I'm not inclined to grant the eviction based on the basis that we have. If in fact she's going to be able to pay her rent, if that's not an allegation that mean, we haven't had any evidence on that, but I mean, if she's offered to pay rent, I think that she should be allowed to pay her rent, and that's not an issue for that. But this is something you would be taking up at county court. If in fact on appeal, if you feel that that's, it's the wrong outcome. But I'm not inclined to grant the eviction based on the other two grounds.
Your Honor, we're withdrawing the non-payment because I didn't ask any questions for non-payment. We're not pleading that. But regarding the criminal conduct, the lease also very clear. The landlord gets to determine, even you hear testimony, you questions the witness's credibility, but you also saw the video. Ms. Law did.
I didn't hear the threaten to kill.
Well, she did say, I'll get somebody to get on you. So some, at least physical violence, but my client get to determine if there's a criminal activity. This is not criminal court. She cannot claim self-defense. And you can ask Ms. Davis or Ms. Neil, they get to determine. There's no guidelines how to determine that, but
but there has to be material, like a material threat. I mean, I'm going to get someone on you means I'm going to have someone come slap you around or talk to you. Doesn't mean you're going to come kill them. And maybe that's how Mr. Martinez interpreted that, but I didn't get there with you on that.
Okay.
So,
Your Honor, this is not the first
incident. Maybe live testimony would do better if this goes to county court and live testimony does it. Then, but I'm not there with you on that. Okay. So,
Your Honor, at this time, if I'm understanding the court correctly, that it's ruling in favor of defendant, we'd like to move for attorney's fees. We sent the court earlier a unsworn declaration by Ruthie Goldstein, and she can talk a little bit more about that.
Your Honor, I would like to object to attorney's fees. Number one, I don't see any pleading for attorney's fees. And number two, pleading for attorney's fees only available when the landlord is entitled to attorney's fees under Texas Property Code 24006.
Your Honor, that's a misstatement of the law. 24.06 says that if the plaintiffs, yes, he's correct that if there's a couple of ways you can get attorney's fees, and that's one is if the lease provides for it, which it doesn't in this case because it's a model lease. But also if the landlord sends a demand stating that they will be seeking attorney's fees as it did in all of its notices to vacate, then the defendant may seek fees in the event that they are the prevailing party. That's also in 24.06.
Your Honor,
okay, I am not going to grant the attorney's fees. I am finding a judgment in favor of defendant. I'm not granting attorney's fees, although I do see in the petition it does ask that they were asked for attorney's fees, but they're not able to get attorney's fees. So I'm not going to grant attorney's fees for the defendant either. So it's kind of splitting the baby there, but I mean, y'all can argue that out in county court, and we'll see what happens at county court if that's the route that plaintiff decides to choose.
Your Honor, then before you render the judgment, can I ask this court to dismiss? Because under the rules of civil procedure, plaintiff can dismiss the case anytime before the court renders a judgment.
It surrendered a judgment, Your Honor.
I rendered the judgment, Mr. Lung. So I'm gonna find in favor of the defendant that but if you'll send me a Ms. Dunlap or Ms. Goldstein a proposed judgment, that's the ruling of the court.
Yes, Your Honor, we'll do that.
Sorry to expedite at the end, but these cases are not pleasant for either side. Ms. Law, there are some behaviors that are questionable that have happened at the property, and I'm sorry what happened to you back in April. If this is not a place where you feel safe, you may want to be looking for somewhere else to live. But I don't feel that the facts as they played out at the property, I don't believe that.
I feel like it was just a big misunderstanding, like from both sides. But at the time, I did feel overwhelmed. I was going through a lot of emotions. I am a single mother of 2 and I'm 22. So the time that I was going at it with Steven, it was not out to threaten him. It was out of hurt because what was being said to me at that time. And then I was dealing with
Ms. Law, please be aware that you are responsible for the actions of any guests that you invite to the property. So,
yes, sir.
That you'll be liable for any things that they do that may be violations of the law because they're your guests. But
yes,
at this point, I'm going to rule in favor of the defendants. There's not an eviction being granted, no attorney's fees being issued for either party. So it'll be a take nothing judgment, which If the plaintiff wishes to appeal, it's a $500 or $200 appeal.
The owner will ask for $200.
We would ask for $500, Your Honor. This is a corporation or a limited partnership. They have lots of means.
All right. I'm gonna set the appeal at $500, and so send that to me, Ms. Holstein or Ms. Dunlap, and I will sign off on that.
Your Honor,
Either most likely tomorrow. Yes, ma'am.
I believe we did send the proposed.
Sorry. I believe we did send the proposed order to the court in that email with our exhibits earlier today, about an hour before the hearing began, about 1 p.m.
We'll track that down then. I don't think it's my queue.
Oh, I can e-file it. I'm sorry.
But like I said, I spoke with both parties before the hearing, and I knew that most likely it won't end here, but Mr. Lung, advise your clients as to how you believe they should proceed if that's what they wish to do, and with the consequences or benefits that will ensue afterward. But like I said, this evictions are never a pleasant thing, but I don't believe that Ms. Law should be evicted at this point in time based on the facts in front of me.
Okay.
Thank you very much.
Yeah, Ms. Goldstein, your proposed judgment do have an eviction attorney's fees paragraph. I will ask you to remove that.
Thank you. I'm going to log off.
Thank you.
Thank you, Judge.
Thank you for your time.